All right, hello. Good afternoon. We're just going to keep it brief, get straight to the point, and especially for those who are either in the US or outside of the US, and you have concerns about the immigration process. I know it may seem a bit bumpy, a bit confusing, and sometimes it depends on who it is, a bit frustrating, the process that is. And so we just want to take this moment to break things down a little bit for you in order to simplify it. Um, so, and how we operate at Penshop Immigration Consultancy is we try as best as possible to protect people's identities. And so um, we are concerned about people's confidentiality. And so we understand that maybe some folks who might be experiencing whatever they may with regards to immigration for them may not want to pose a question publicly. And so, in a very simplistic form, we want to break things down so that you can, if you have a relative or if you're planning to file, that you can have at least a better understanding about the process. There are several subjects that we want to deal with today. And just so you know, um, we are talking about what the law says. We are talking about the procedures. We're not basically here to advise you on what you should do and how you should do it. We're just here to talk about the law, immigration law, and procedures and so forth. That's all we wish to talk about. Just to have you know that at least at this point, I am not presenting myself as an immigration lawyer. And so at this time, I just want to make that clear that I'm an immigration consultant, qualified, by the way, with an advanced degree in immigration law, an advanced certificate in immigration law. And so just so that you know, that whenever I talk about these issues, I am just not guessing my way. I'm telling you what the law says. And again, for those of you wherever you are, good afternoon. And as I've said, I'm just going to keep this very brief, straight to the point, because we at Benchop Immigration Consultancy, we've been getting lots of calls and queries from individuals who are concerned, maybe if they have a pending case with USCIS, or people who are contemplating in very, very near future to petition for a loved one, whether it's a wife, whether it's a husband, whether it's a child, or whatever. And especially if you are in the United States of America. But let us touch on those who are outside of the US and they are awaiting an interview. It is called a consular process, a consular interview. And you can get to that stage only after there's an approval of your I-130 petition. So if you have an I-130 petition and it's been approved, USCIS is going to send that to the NVC. The NVC is actually the National Visa Center. And what happens at the National Visa Center after your I-130 has been approved, then it goes to the NVC, the National Visa Center. Then the National Visa Center does whatever it is, as long as you have a visa that's available. There are different categories. So if, for example, you're married to a US citizen and your I-130 is approved, then it goes to the NVC, which is the National Visa Center. The NVC now, based on the category, the NVC will now say they're ready to proceed with your case. That is because an immigrant visa has become available for you, and they will send that package to the US Embassy, and you now will be notified that you could go to the next level, which is to pay your fees, which is an additional fee that you have to pay. Once NVC say that they're ready for you, you pay that fee, you prepare an affidavit of support, and it has to be done properly, because what they do now, it's not like before 2 pages or 3 pages or something like that. They're looking for a heck of a lot of information. And that is why you've got to take your time. That is why we say to our clients, those of you who know me, oftentimes you hear this word from me: be patient. Be patient. Let it be done. Let it be done properly. And so far, so good. We're not in the business or so forth or getting anybody being upset because they've been denied or whatever. And hence the reason why we take our time and get it done and get it done properly. Because as of now, these times are different times. And so it has to be done properly. If it's not done properly, the Trump administration has instructed USCIS officers to deny applications on the spot. And so that is why it is important. And sometimes your anxiety and, as human beings, you want it to be done, you want it to be done now, and so forth and so on. But thankfully, we have very patient clients. And so I'm just saying, in general, do not rush the brush, as we would say in Guyana. Do not rush it, because there's lots and lots of things that need to be done. And so it has to be done properly. So let us get back to the consular interview process. The Trump administration has said, put on pause at all U.S. embassies, to put a pause on interviews for immigrant visa. Now, immigrant visa, to break it down for those of you, an immigrant visa is when you're migrating to the US. We're talking about the US here specifically, waiting to get a green card. And so the process is you have to go in after you finish the other levels in terms of the application process. You finish with your medical and so forth. And the embassy says, well, we are ready for you for an interview now. And you get all dressed up and you put on a nice pantsuit, you put on a nice shirt, a nice suit, and you get all dolled up, so to speak, as we would say, for this interview. So when you go in for the interview, the officers already, they know what you're about. They read ahead of time um, your application. They pretty much know, but they just want to hear it from you. And that is why they're interviewing you. One, to make sure it's you. Two, to make sure the information that you put on your application is pretty much accurate. And so, and to vet you. But what the Trump administration is saying, they got to increase that level of vetting as of now. And so they put on pause. And I suspect maybe by mid next month, September, they are going to remove that pause. And consular officers are now going to, what the administration is saying, properly train how to detect, and this is important for you to know, how to detect individuals who are likely to become a public charge. And the meaning for that likely to become a public charge. Say, for example, they see on the application that you do not have a strong family foundation in the U.S. That maybe the person who sponsored you or petitioned for you doesn't work or doesn't make much, and these sort of things. So they are going to look at those things, and it gives the consular officer now the full authority to either deny the application or approve the application. If they feel that you are going to come, and let me just break down public charge, basically means if you are going to come to the United States to become a burden on taxpayers, not my words, mind you, and so I don't want to come across as if I'm being insensitive to anybody out there, but that's the administration. So they're saying, the Trump administration is saying to consular offices, and again, consular offices are through the embassies when you go in for your interview. And this is about immigrant visa. Immigrant visa. We're not talking about visitors visa here. We may get to that later on. And so when the consular officer is going to interview you, they're going to say, okay, maybe Tom or Jones or Harry or whatever, I don't like how this application is going. Tom or Joan or Harry may come to the United States. When they come to the United States, if we give them this immigrant visa, if we approve them for a green card, then when they come to the United States of America, Tom, Jane, Joan, Harry, whomever it is, Savitri, whomever it is, once they come to the US, they're more likely to be on welfare, to break it down, to depend on taxpayers of the United States of America. That is what the public charge stuff is all about. And so the Trump administration is saying they want those individuals coming to the United States and who are likely to become a burden. They do not want them entering into the United States of America. For the most part, that is what this is about. And so the consular offices now are in training. Maybe they have started online training and so forth through training sessions at the various embassies. And I'm just assuming here, right? Because they did say that these officers are going to be trained. So you don't expect all of them to fly back to the United States for training. So I'm assuming that they're at those embassies abroad, the US embassies, the training process may have already begun. Again, that's just my opinion, but probably by mid-September, they're going to remove that pause and restart interviewing process. Again, that's just my prediction. And so say, for example, if you're migrating, somebody petitioned for you for a green card and you're going in for that interview at the US Embassy, let's say in Georgetown, Guyana, or in Jamaica, Kingston, or in wherever else, Port of Spain, Trinidad and Tobago. They also look at your medical record. Under the Biden administration, they say, we don't care what happened to you. We don't care what you have. We don't care what sicknesses or what disease, or we don't care. That's the Biden administration. Because the first Trump administration had put a ban on individuals for certain medical situation they may have found themselves in. And the Biden administration said, no, we are not going to discriminate against any individual as a result of their health situation. And so when Biden got into office, he wrote, what is it? He signed an order, an executive order saying now, and instructed USCIS not to discriminate against anyone on the basis of their health or whatever sickness. Now we're back to that now, where the Trump administration is saying, hey, wait a minute. If you have certain illness or you experiencing certain health crisis, maybe you are on dialysis. I'm just using that as an example, mind you, or maybe you have some sort of severe health complications. The Trump administration they're not saying that they're going to ban individuals of such. So let me just make that pretty clear based on my understanding. What the Trump administration is saying is that they want the consular officers to make that final determination as to whether that person will become a burden on taxpayers of the United States of America. So let me make this quite clear. As far as I'm aware, the Trump administration is not saying they're barring individuals because of health reasons from coming to the United States as immigrants through the consular process. They're not saying that. What they're saying is that it is going to be determined on a case-by-case basis. And so that final determination would be on the consular officer who is conducting that interview. So in essence, the consular officer has a tremendous amount of powers right now to say yes or to say no. And so if they look at that application and they decided even ahead of time, oh, I don't like this person. Well, they're not going to say because they don't like this person. They're going to say, well, because they get a copy of your medical record once you conduct your medical. They get a copy of that record and they're able to view your medical history. And in viewing that, the officer can possibly be able to make a decision, say, this looks a little bit iffy, right? Not iffy, sorry. And so when you go in for that interview now, that is when the officer is going to try to get some more information from you. And in getting more information from you, based on how you look, if you're like muscular like me, or you're muscular like some of the other muscular individuals, or you're strong like some of our viewers here, then the officer would be able to make that final determination based on maybe physical appearance too, that you're strong enough, that you're capable of working, and you're pretty strong, right? That is how they make that final determination. A lot of factors, not just one thing. They're not going to see on your medical that you're suffering from something and then make that final determination to say, we don't want you here. They're not going to do that. So do not panic. Do not give up hope, which is what we oftentimes say to people. Do not give up hope. Go into that interview, and of course, they'll be able to, again, as I've said, make that final determination. And it has to do also, they will check your educational background, if you dropped out of high school, if you, they'll check all of this. And not because somebody dropped out of high school or dropped out of primary school or they didn't finish up, or what, it doesn't, they're not going to use that to block you from coming to the United States of America also. So do not panic, guys. Do not allow anyone to make you panic. Take it easy. There are different layers, there are different factors that the consular officers are going to use to determine eligibility, whether you're worthy of coming to the United States as an immigrant with an immigrant visa. So do not panic at all. The other thing that they are going to look at in terms of your education, whether you have a degree, whether you have a skill, That is why on the IV, the immigrant visa application, there's this question about your school, about your background, your level of education. How far have you gone? Whether you've gone through primary school, whether you've gone through high school, what level, university, and so forth. That would be able to determine now, of course, give them a glimpse of your educational background. The other thing also is your skill. You don't necessarily have to have, they're not looking to see if you have a university degree and say, oh, we want you. And somebody who doesn't have a university degree say, no, we don't want you. That's not how it's going to be determined. So let's say, for example, you do not have a university degree or a high school diploma or whatever, but you have a training school, you have a trade. You are a tradesman or a tradeswoman, you're talented, you're gifted as to what you do, and your job history as well. They look at all of that in terms of determining whether you are admissible into the United States as an immigrant. And therefore, that will assist a heck of a lot in the final determination of the consular officer approving your immigrant visa application. So that is on pause right now. All interviews for immigrant visas are currently on pause. So if you were expecting an interview, that is on pause for now. It may slow up the system a little bit, but because it's behind by years, because as it pertains to Guyana, it's thousands upon thousands of people. And sometimes many of you who don't know, people have to wait at least 10, 15, sometimes longer than that. And it's unfair because when your loved ones petition for you, the child may be 10 years, maybe 15 years. And then because of the length of time, because of the category also, that child is aged out. We've had some experiences where the child passed 21 and in some cases past 22, and they were lucky enough to have been given their immigrant visas. And so we say this because, not because someone turns 21 means that automatically they're aged out. There are lots of other contributing factors. And do not put your hands up in the air. Do not give up. If your application is going to be done, it has to be done properly, especially now. And if it takes some time, a couple of extra days, whatever, for more evidence, because the more evidence you give now, the better chance you stand in getting your stuff approved. Having said that, let's touch now on the visitor's visa aspect of things. If you're coming up on a B1, B2 visa, and you want to be here in the United States for vacation, mind you, ensure that it is a short vacation. Nobody goes on vacation for 4 months, 5 months, 6 months, 3 months, and so forth. The officers are going to look at that. And when you come to the United States on a visitor's visa, ensure you are visiting. Even if you catch a small piece, one of the relatives, like you run into one of your relatives, they put a little 500 in your hand, bless you up, so to speak. You're not working because you're not allowed to work on a B1, B2 visa, a visitor's visa. You're not allowed to. Even if you do here, you're not allowed to do here. Or nails and some relative give you a raise and it is considered working. So be extra careful because it can cost you your visa when you go to reapply. So be extra careful with what you do on your B1, B2 visitor's visa. And they do not expect you to come every other 3 months, every other 4 months, and so forth. Be extra careful with that as well. The other thing that the Trump administration is cracking down on is those who come to the United States on a B1, B2 visa. That is a visitor's visa. Again, coming to the United States on a visitor's visa and then seeking medical attention. That, according to Trump administration, that has always been there, mind you. It is not something new under the Trump administration. It has always been there. It's just that this administration is now enforcing it. So it's not a new law nothing. It has always been there, but they're enforcing it right now. So be extra careful as well. You don't want, one, your visa to be revoked or canceled. Secondly, you don't want when you apply to renew your visa and it is not granted, because the consular officer, they will see your entire travel history. They will know when you left for the US and when you leave the US or back to your country, when it's Jamaica, Guyana, Barbados, wherever. So you want to treat your visitor's visa like a visitor's visa. The other thing, some of you, if you have applied for a visitor's visa, you may have been experiencing a long wait before an interview, sometimes 3 months, sometimes 4 months, sometimes 5 months. The system has changed. It is not like before you get an interview within a couple of days, maybe a week, maybe 2 weeks or whatever, or you have that option. When you do that visitor's visa application, you would see that as of now, the last that we did a couple of days ago has to go in for an interview till February of next year. And so when you check the schedule, the availability for an early date, it is just not there. And so your application is in there because, one, they're vetting you, they're vetting every single person. So it would take a longer period of time, hence the reason why it is such a long, long time. The backlog is just too much. Now let's move from the visitor's visa, and we want to touch, like I said, I'm going to be brief with you guys. We want to touch on the marriage-based visa. Marriage-based immigrant, that is for the green card, it is where you got married and you decided now that you want to file for your spouse, whether it's your wife, whether it's your husband, and file for those individuals. The process is going to get tedious. And what do I mean by tedious? It's going to get a little more difficult. Difficult doesn't mean bad, but they are going to scrutinize applicants more. For example, sometime mid-September, the application for a green card, it's going to get, or there is going to be an increase in terms of the pages, in terms of information. You're going to have to put lots and lots more information. You're going to have to get lots and lots more evidence to prove so many different things. You're going to have to explain why you overstayed your time and so forth and so on. It's not like you didn't have to. So these things are not new. But what the Trump administration is doing is tightening the screws, as we would say in the Caribbean. They're tightening things now. They want to make sure that this is a bona fide, meaning it is a legitimate marriage and not a marriage for a green card. In the past, the application forms were like maybe 3, 4, 5, 6, or 7 pages. The green card application is about 24 pages. 24 pages. Don't be surprised if it jumps from 24 pages to maybe 28 or maybe 30 pages. There will be some changes. And so as of the 18th or the 15th of September, the old application form will no longer be accepted. So the old one now, if you are, or if you decide and you're doing your stuff on your own, and by the way, if you're doing it on your own and you do not really understand the process, because it is not as simple as it used to be. One error, one slight mistake, the officer, according to the Trump administration, the officer has that power to reject your application on the spot, or deny your application on the spot. And what happens when your application is denied on the spot? You can guess what happens. if your application, one, your green card application through husband petition for you or your wife petition for you, we are sticking to marriage-based petition right now. If the officer feels that there is not sufficient evidence to back up your claim of a bona fide marriage, the officer has that power, that authority right now to deny your application on the spot. Once your application is denied, it gets put, depending on the officer, it gets put almost immediately in removal. That is what Trump administration is saying. Usually you have a 30 days or a 31 or 32. It depends on how you received your correspondence or correspondences from USCIS to apply, not to appeal, but to reopen or to reconsider the decision. That is done through another application form that's called a 290B, which is sometimes it's easy to win, but sometimes it's difficult because some lawyers will argue that a 290B is tough, but we've had some good experiences with 290Bs. And sometimes though with 290Bs, it takes a year, sometimes it takes a long time. The fastest that we have had a 290B to approve, and it's really fast, in less than 5 days after the 290B went in. And that was the fastest for us, a 290B. So they're not going to focus much, even though the law says that you should get that opportunity to ask for your case to be reconsidered through a 290B. You're still entitled to that. But what I'm saying is the officer adjudicating your matter has full authority to either reject, and the officer can reject because something on the application is missing. That is why it's important. And let me get to this key point. That is why it's important. And we oftentimes say this to all of our clients. Do not rush. Not because somebody told you that they have ICE officers in Queens or ICE officers in Brooklyn or in New Jersey or in Atlanta or wherever in your area, that you're going to panic and you're going to want to rush something through the system. That is not the way to go. Now, while we understand your concern, we respect your concerns, but based on what is happening now, we say if an application or applications are going to go in the system to USCIS, one thing, it's got to be bona fide, has to be bona fide, has to be legit, in other words, what I'm saying. So you come to us with legit application. We will ensure that it is done timely basis because we operate on time as well. And once we are satisfied, after reviewing your application, after checking the evidence, and we are satisfied that there is a preponderance of evidence in your favor, then we are going to release that application into the hands of USCIS. So if I make a final determination, reading your application before we send it off, and I'm not satisfied that there is sufficient information, I am not going to send your application in. Reason being is because it is to protect you. I do not want your application to fail. I do not want you to fail. And so we are not going to rush to put your application in the system to look good and to say to you, oh yeah, your application went off. Oh, it went off. Oh, it went off. We're not going to do that. As I say to all of my clients, every single one of them, that first and foremost, I apply my human rights background on every application because we do have that human rights touch. And when we see a case, we want everyone to succeed. And how are you going to succeed? You're going to succeed if it's done properly, the right information, the proper set of evidence, and so forth, especially these times. Then we are going to send that into USCIS to make that determination. Now, what else is it that we can talk about before? The other thing is, I want to touch on the VAWA application. VAWA is Victim Against Women, and that is what it's about. but not because it says victim against women means that it's just women. Men also can apply for VAWA. Kids can also apply for VAWA. But a VAWA application, like all other applications, have to be a legitimate application. It cannot be done through fraudulent means because USCIS in most cases will catch up with the fraud. And when they do, they are going to deny the application. If you have a work permit or whatever, they will revoke your work permit and they will, in most cases, immediately put you in removal. And so you've got to be extra careful with your yeah, sorry about that, guys. So they are going to say, my apologies there. They are going to say they need evidence. So if you have, let me just say, sorry about that, guys. Some people just saying, oh, market. Technology, sometimes things do happen. Thankfully, it's not blackout. But let me say good afternoon to some of you there, Patricia, Brenda, Wayne, Caesar Wayne doesn't miss a program. Good, good. Savitri Rose and Devon, Fanfare, and the whole crew. How are you guys doing? All of you. So let me say this here, that if you say that your spouse abused you physically, they're going to want to see the evidence. Whatever evidence you have, if you have any marks of violence or whatever, you have to present that. Not through video or audio. It has to be, of course, a photograph. So if you get palm up in your head or whatever, and again, I'm saying this not to be insensitive. I'm just saying this to say what are some of the evidence if you talk about physical violence and you have photographs. It makes your VAWA case stronger. If there is a police report, then you have to get a copy of your police report. If you have gone through counseling and so forth, they want to see that report as well. And those are some of the things that will make your VAWA application very strong. They have quite a lot of people who have went through a route, a VAWA route that was not, in the eyes of USCIS, legit. Not my interpretation of what is legitimate or not, but quite a few folks went a different route and they were able to acquire their work permit. And even though it came through USCIS, USCIS has been able to determine that it was not done through a legitimate process, meaning the information that was given on those VAWA applications were not legit. They were basically fraudulent. And so if anybody really comes and say that they're doing a VAWA application, you've got to know exactly, you've got to present the evidence, you've got to basically know what is on your VAWA application. Just like in every other application, you've got to know what is being put, and specifically your VAWA application, which is very, very sensitive. Because if you notice, USCIS, they wouldn't even want to release these sensitive information to you just like that. That is how sensitive a VAWA application is. So if someone is doing a VAWA application for you, all of the information would have to be legitimate, bona fide information. So you don't want somebody to send in a supposedly skeleton application for your VAWA where you don't know anything about what is being put in that application, or wrong or corrupt information. If that happens, then it corrupts the entire process and it makes it appear as though you are committing a fraud. And that is why it's important. Do not let somebody or anybody says they are going to give you a work permit just like that. There is a process and you have to go through that process. It's got to be a legitimate process. And even though it's done through USCIS, it still has to be legitimate, the information. And that is why if there is a VAWA application and you say that your husband abused you, then the evidence would have to be presented, such as marriage certificate, to prove that you're indeed married. And that this person that you're alleging, whether it's a husband or wife that has abused you, you are showing that piece of evidence that you were entered into a bona fide marriage. And as a result of that, you are now seeking the help or the mercy of the US immigration system, because you are now claiming that you're a victim. And therefore, you have to prove that you are a victim by submitting certain essential pieces of evidence. If you send in a VAWA application that is very skinny, where there is not much information, but you got your work permit and you're all happy, and then they're sending for further evidence, it's called a RFE, request for further evidence, and you do not respond, your case is going to die a natural death. And when it dies a natural death, your work permit gets revoked and all sorts of things, and you are more likely to be placed in removal. So you've got to protect yourself. And that is why it's important. It's important that when you go to individuals to do, I'm not here to knock anybody. USCIS will do whatever they have to do. I'm just cautioning you that these sensitive applications have to be done with your knowledge, and it has to have legitimate information on them. Evidence would have to be presented. If nothing is presented, your case will die a natural death. And the other thing is, you have to have control, or there has to be transparency. You have to know what's going on with your case. You don't want someone to do your case and then they hold on to all of that information and you don't know what's going on with your case, and they're just telling you, oh, this is what is happening. Oh, they don't need any more information. Here is your work permit, and that's it, right? If you know where I'm getting at with that, right? Then you won't know what USCIS is saying about your case. And you are more likely, if you don't know what's happening in your case with these VAWA application, you are more likely to end up, you know where, in front of an immigration judge for removal. Scores of people are experiencing that right now. It's sad. It's unfortunate. Therefore, you have to open your eyes and be extra careful, because in law, there is a saying that goes, ignorance of the law is no excuse, none whatsoever. So you cannot go in front of the judge and say, I didn't know. Ignorance of the law is no excuse. And therefore, anyone who's doing a VAWA application for you, or applications in general, you will have to be toe-to-toe with that individual and to know that the evidence, what is being put in that application, is exactly the correct evidence. Nothing fraudulent, because if it is deemed to be fraudulent, according to immigration law, you can be permanently banned from the United States for submitting fraudulent information. So be extra, extra careful. What else you want to touch on? Maybe we can touch on citizenship application right now. Citizenship application as of now. So, sorry about that, folks. Not right now. So let's touch on the citizenship application at this time. So if you're looking to file for your citizenship application, now is the time to do it. Because here is what I suspect, that the price may go up, the cost may go up. But what we do know is that apart from the cost, and this is just my prediction, that the cost may go up. Right now, it's $760 to file for your citizenship if you're filing physically. If it's done online, it's about $710, I believe. I suspect that, don't be surprised, mind you. Do not be surprised if the price goes up for citizenship application. But what they're looking for is more and more information to ensure that you are worthy. That's what they're looking for. So now is the time also to file for your citizenship application. You've got to do it, because a lot of things, I repeat, a lot of things may get tougher. A lot of things, it will get more and more difficult, more and more information, and all these different things. So if you are in the habit of procrastinating on these important things, stop the procrastination and get the ball rolling ASAP. The other thing I want to talk about before I go, we just have a few minutes remaining. I want to touch on this other stuff. It's called a conditional green card. If you have a conditional green card, it means that you entered into a marriage less than 2 years and you got your interview, and so they approved your I-485 application. They are not going to give you a 10-year green card. They are going to give you a 2-year green card. Now, the reason is pretty obvious why they gave you, why they would give you a 2-year green card. They'll give you a 2-year green card because they're testing you. 2 years, or just before the 2 years expires, maybe 90 days before the 2 years expires, you can submit an application, which is an I-751, to renew or to remove, the conditions of your green card. Now, when you submit an application to renew the conditions of your green card, you cannot submit the same thing that you submitted before. You can, yeah, but you have to add more stuff. They want to see that you guys are living the kind of life that you presented yourself as man and wife. They want to see taxes together. If you guys get children or one child or 2 kids during that process, they want to see that. And sometimes that helps when you have kids during that process. They see that it's a bona fide marriage. But even if you don't have kids, they want to see that you file taxes together. They want to see that you have things in your names. They want to see that you travel together. They want to see that you went out to eat together. And it doesn't matter where you take your spouse. It could be McDonald's, it could be Burger King, it could be Sybil's, it could be Golden Crust, or it could be a fancy restaurant. All of these things, they're looking to see evidence that you guys were able to build a life together. That is what they want to see. If you got your green card approved, your conditional green card, and you were not on the lease, go on the lease now. All of these things they want to see. So that is why 2 years, or at least 3 months before the 2 years is up, you have to send in your 751 to remove the conditions. And you're asking them, you say, look, we're together still, we're madly in love, we have a car together, we have insurance together, we now have a bank account, and here you go. We just got our first apartment together, our 1 bedroom or 2 bedrooms, or even a studio. And you say, look, we have the lease in our names. Look, we file taxes, joint taxes. Look, we own something else. Look, we went to the Bahamas together. We went to Guyana together. We went to Jamaica together. Here is the itinerary from the travel agency or the airline. They're looking for that sort of evidence. They want to see. Here is photographs with us together. We just took a nice selfie. Look, we are hugging each other. We're still madly in love. They want to see that. But let us say something happens along the line and things didn't really work out. It went south. This And you can still file to remove the conditions. And in filing to remove the conditions, you now have to explain to USCIS what happened with the marriage. Tell us what went wrong with this marriage. Oh, we feel sorry for you, Josephine, or whomever. Oh, what happened to this marriage? Oh, things didn't work out. We entered, what they want to see to begin with is that you say to them, prove to them that you entered that marriage in good faith. Oh, I loved her, or you loved him. But it didn't work out because of X, Y, and Z, because you were abused, because you had to call the cops on him a couple of times, or he had to call the cops on you a couple of times. And you present that evidence that you did all that you possibly could have done to save that marriage, but things happen. And so they will entertain that application, even though you're filing and you and your wife or you and your husband or your spouse, that y'all are not on the same page. She moved out of the house, or he moved out of the house, or the spouse moved out of the house and went somewhere else. You can still file to remove the conditions. They will review, based on the circumstances, and they will make a determination. And in most cases, it will be a positive determination. We have had a case where a couple months ago, and it was a very strong case. And the person was granted their 10-year green, even without. Yeah, there's a situation where folks I don't know, some folks calling while I'm on here. I don't know. Can I call while I'm on here? So basically, there is still a way out, of this situation. And therefore, it's not the end of the road. The other thing some folks are concerned about is what about if there is a divorce? Good question. If there is a divorce, you can still file for your conditions to be removed. But again, you have to prove that the marriage is actually a bona fide marriage, that you entered that marriage genuinely, and then things, like I said, things work out, or things didn't work out how they should have, and therefore you're asking USCIS to consider granting you or removing the conditions from your green card and give you that 10-year green card. Lots of you want that, and it's not the end of the road, even if you're divorced. Based on the circumstances, just ensure that you have somebody who is who is knowledgeable enough to send the correct set of evidence in to USCIS. And so the other thing as it pertains to the removal of conditions is when your application goes in, you will get an automatic 48-month extension. With that, you can travel. But as of now, it's up to you to make that decision whether you want to travel or not. Well, I would say to people, is be careful in traveling under the circumstances and the situation now. Just be extra careful. I notice Devon Fanfair is correct. Procrastination is a theft of time. So true, Mr. Fanfair. Now, with the 751, once you get a 48 months extension, when you approach 3 years of your green card, you can file for your citizenship, even though your 751 has not been approved as yet. You can still file, once it's a marriage-based petition, you can still file for your citizenship during that process. So you will have two applications in the system. You will have your citizenship application, which is your N400, and you will have your I-751, which is your removal of conditions application in the system. It works. We have had clients where we know that it works. Now, the process is once you're approaching the 3 years and you haven't yet had your conditions removed, you're going to have your citizenship application sent in, and you're going to say to them that you're still awaiting the final adjudication of your 751, I-751, to remove your conditions on your green card, and you're now applying for citizenship because you can. You're married to a U.S. citizen, of course, and you are qualified to apply for your citizenship, and that's what you do. So when you do that now, USCIS is going to look, and they are going to ask, more likely the case is going to reach at the supervisory level, and the supervisor may ask, what's going on with this here? Do we have sufficient evidence? Should we just schedule the interview for the 751 so that we can get these conditions removed and immediately place them in line for an interview for their citizenship? Note, you're not going to get your citizenship interview before your conditions are removed. Your conditions on your green card have to be removed before your citizenship interview. Oftentimes, at least based on our experience here at Benchop Immigration, it is helpful. Once you are qualified to file for citizenship, it is helpful with the case. In most cases, not necessarily all, because sometimes they do still take their time. And so there are other instances where the interview or interviews can be done simultaneously, meaning you go in for your I-751 to remove your conditions, and the same officer can also interview you for your citizenship interview. So you could kill two birds with one stone on the same day. Or they will approve the removal of your conditions of your green card and issue you with a 10-year green card, and not so long after, schedule your interview for your citizenship. You've got to read up on the test, on the questions, and you've got to be knowledgeable about U.S. history. It has gotten a bit tougher, but I'm sure that you guys can do it. And now, for those of you who cannot read and write properly, those of you who may be suffering from whatever it is that you're suffering from, there is still a way out of it. And what is that way, somebody may ask? What is that way? Somebody may say, Benja, what is that way? Tell us, please, what is that way? Well, if for some reason or the other that you cannot read and write properly, there is a way out, and you have to have, and through USCIS, they allow that to happen. You have to have a medical reason, and you have to be seen by a doctor. And that doctor is going to examine, they're going to examine you, and they're going to fill out an application, a form, to present their results to USCIS officer to say Tom Jones or whomever, or Drupati or whomever can't read and write properly as a result of X, Y, and Z. And it must be done properly, it must be legit, and it must be a doctor who is qualified to do that, because they will ask for the medical certificate number or license number, and all these things they will ask for. So you can't beat the system just like that, I would say. You cannot beat the system just like that. So everything has to be legit and bona fide, of course. So there is still a way out. We have had some clients who have difficulties reading or understanding ABCs and so forth, and they were able to overcome that through explaining to USCIS why they cannot read and write, why they cannot comprehend, or why they cannot answer certain questions. So there's still a way out. It's not the end of the road. Now, with regards to convictions and all these sort of things, got to be based on the convictions, minor charges, and these sort of things. They're looking into everything. And so you've got to be honest, you've got to be clear, and you've got to say X, Y, and Z. This is it. And you've got to present the disposition also. So you go down by the courthouse, you get a copy of the disposition, you present it to them, and they're able to make, the officer that is, would be able to make that final determination on your case. The other thing, as we look to wrap up, if you have a petition that is pending, whether for a green card, whether through a spouse or a child of a U.S., you have a child, a U.S. citizen who's over the age of 21, filed for you, they also look at your criminal history. They want to make sure that you have not had any arrests during your time here as you wait your application process to conclude. And so they would know everything. And so you have to be honest with them. We've had a couple of clients with marijuana charges and so forth, and they have been successful. All they want is declaration to say, hey, X, Y, and Z. We have had a client, and this client didn't declare their arrest record. And when they went, the officer said, but you were arrested, but you didn't tell us that you were arrested. Why didn't you tell us? And based on the explanation, I think the officer was able to accept that explanation, and the person was granted their green card. So that was probably that person's lucky day, so to speak. But in all these situations, circumstances, you have to make that declaration. You have to do that. Quickly before we go, as I would say to individuals, all of our clients, we want to see you succeed. We're here to walk you through that process in a legitimate way. And so this is not an overnight thing. It takes time. There is a process. It has to be done properly. And that is what we do right here at Benshaw Consultancy. So it's not like you pick up the phone and expect it to be done tomorrow or the next day. We have scores of other people, and we want all of your applications to be treated with respect, confidentiality, and of course, dignity with all of you, every single one of you. And that is why we respect every client. And so your case remains with us. If you notice, we just say congratulations to our clients. During these periods, these times, we do not reveal our clients. We don't want no photographs. We don't want anything. Other people are free to do what they want to do. But we just don't do that because we know of the times that we're living in. We understand the times that we're living in. And so we respect that. And we have that human rights touch to every application. We take you from beginning to end, all to the finishing line. And for marriage-based petitions, husbands and wives, partners, here's what I have to say to you. When you go in for your interview, our job is to make sure the doors for that interview or those interviews are set. We cannot go in and answer personal questions, and the officers are going to ask very personal questions sometimes. They want to know what side of the bed you sleep on. They want to know what you guys had for breakfast. They want to know whether you took a shower this morning or not. All of these things. They want to know date of birth. They want to know where you met, how you met, who proposed to who. Those are questions you guys as man and wives, husband and wives, as partners, ought to be able to answer. All the best to you guys. If you're going in for your interviews, we wish you all the best. But like I said, we are with you from beginning to end. And let me take this time to congratulate. We've had over the past couple of days quite a few applicants, quite a few clients who have gotten their green card applications approved. Some are in the process of waiting to receive their green cards. Congratulations to them. We have some citizenship applications approved, and there are some who are still awaiting their interview. There are some folks who are going in for their interviews for marriage-based petition. We wish them all the best. We know that they are going to be successful because not just that you're in good hands, it's that we take care of you from beginning to end. All you've got to do is to be patient. We make it happen for you. We know your case is important and we treat it as such. Now, there was someone who, somebody asked a question here. Let me just, out of respect, see what this question is. Mr. Benchop, I have a question. I have a friend that went home, I guess she's saying here, and got married to this guy. She brought him up here about 3 years ago now, and he's still without a green card. Can that be possible? Well, I don't know the circumstances, so she brought him up. I'm assuming that he went through consular interview and he came up and he hasn't received his green card. Well, that's highly questionable at this time, because once you're granted an immigrant visa and you go through that consular process and you're approved, it doesn't mean that you are automatically the holder of a green card. You officially become a permanent resident once you arrive at the airport. If you're using JFK or some other airport, as soon as you get to that airport and you present your immigrant visa to the officer, they will go through that process. One, to take a look and review your application again. And then, well, not your application, review the evidence and the approval notice and the letters and so forth. And then they will make that final determination whether to stamp, your passport as a green card holder. So it is not official when you are granted that immigration visa stamp in your passport from the embassy. It is not yet official. You're not officially a green card holder. You become a green card holder once you present yourself at the port of entry with that immigrant visa stamp in your passport. Once you present that to the officer at the port of entry, and the officer is satisfied that you are who you are, everything is legit, and they, boom, stamp your passport, then you become an immigrant. Then you become a permanent resident. That is what happens. You become a permanent resident at that point in time. And one, in case you haven't done that before, sorry about that. People just they wait until thing and then see you on. Sorry about that. So you sorry about that. So you do not become a permanent resident until that is stamped. So the other thing is, the process is not yet over. And this goes back to Ms. Johnson's question. So I don't know the circumstances. I wouldn't be able to answer why this person has not gotten his green card after 3 years. I wouldn't be able to answer that, with all due respect, without the circumstances, because I don't know whether he was approved at the embassy. I don't know. But if take into account that if he was approved and he came here as an immigrant and he was stamped at the airport as an official permanent resident, and he hasn't gotten his green card as yet. So there are two things that, it's kind of strange though, right? But there are two things. Once your immigrant visa is approved, you could either pay another fee, I believe it's $235, that is for your green card processing fee. If you don't pay that fee, you're not going to get that green card. That's one. And you're not going to get that green card until you are physically present in the United States of America, once you pass through the port of entry as an immigrant now, and the officer stamps your passport and welcomes you as a new immigrant of the United States of America. Only then your green card will be officially processed and mailed out to you. Now, mailing is important. You've got to give the correct mailing address, because if you don't, can't eat your dinner, so to speak. Or you send it to an address and the person doesn't want to give you your green card because of some situation. Of course, it's illegal, but it is why you have to be careful. Your address where your green card is being sent is very important. And so you've got to be extra careful. You've got to take your time with your case. Again, I emphasize, rushing your case is not the best option at all. Everyone wants an opportunity for themselves, for their children, for their spouses, or whatever. Everyone wants that opportunity. But things have gotten a bit tougher now, so to speak, with the application process. Lots and lots of information. And people want to, if it's a law firm, if it's people like me, and immigration consultant, and so forth, and then there are those who prepare, and so forth. It doesn't matter. And even if you do it yourself, because everybody's into business. People, you've got to, and I'm not here to knock anyone at all. I'm not going to do that. But if you're going to do your application, or anybody that's doing your application, it has to be done properly. Don't let your head speed you, don't let anxiety, and expect that it's going to be, you're going to get a decision overnight. Remember, not even a lawyer can dictate to USCIS when to adjudicate on your case. Not even a lawyer has the power to pick up the phone and call USCIS and say, I want you to deal with my case right now. No, it doesn't operate like that at all. But most of our cases, I would say, majority of them have been adjudicated on within a reasonable space of time. And we have seen some miracles, mind you. Just the other day, a woman got her green card application approved in less than 2.5 months. Yet less than 2.5 months without an interview. Less than 2.5 months without an interview. And we have had within less than a month 2 individuals here in the United States who have passed the age of 21 have gotten their green card applications approved. One with an interview and one without an interview. So we are seeing a process that is fast. We're seeing a process that we believe to be fair. We are seeing that process, just my opinion, because we are seeing a lot of good works, good, progress report. The only time sometimes you find like there's a hiccup with a case is if they have multiple applications in the system. And when you have multiple applications in the system, and sometimes one of those applications are somewhat questionable, or one of those applications, is questionable, then it becomes problematic. Problematic in a sense that the officers now, they would want to review and see what's happening with these cases, what's happening with this particular application, how do we move forward, and so forth. So it can be a bit complex. So for the most part, we overcome that. And I say to my clients, we are here to overcome sometimes big burdens, and we have overcome big burdens. One more thing, I know I keep saying one more thing, but before we go, I want to touch on folks who are considered to be inadmissible in the United States of America. It's not the end of the world. You have your I-130 approved, you go in for your interview, and the officer said, no, We are not going to, we want to approve your application here at NBC, but you have to remove that stuff that is hanging over your head. You're inadmissible. Sometimes those application process can be tedious. A year and a half, 2 years, 3 years, 4 years, and so forth. Let me just make it clear. It's not an overnight process. We want to see you at the finishing line, but it's not an overnight process at all. There are lots and lots of work that needs to be done, just like with every other application. It's becoming more and more difficult, but being difficult, it doesn't mean that you're not going to get through. It just means that you have to be patient. And that is what we say again to all of our clients. Be patient. It's a lot of work. It's a lot of time. And in some instances, depending on who it is, where you go, it's a lot of money that you have to pay for these things. We try to make it easier for you. We try to make it less stressful for you. And in most instances, 99.9%, we take you to the finishing line with success and victory. God bless you, and continue being safe, and have a great day. And to all of our clients, congratulations, those who have already gotten through and moved on and became citizens and so forth, and who just recently got through. Congratulations to you. Those who have applications that are pending, we're watching. There are a little bit of glitches at the side of USCIS. Some of you gotten your letters, some of you don't get letters. So we don't know what's going on there as well. USCIS did say that there's some glitches in their system, and we're hoping that that can be resolved as quickly as possible. Keep hope alive. We're here for you, and we add that human rights touch to every application, because when you succeed, we succeed. We are more than just succeed. We are happy, because we love to see people happy, and we love to see that approval button. We love to see that approved notice. We love to see that interview notice. We're all happy for you. God bless you, and take care.
Basement level vibe.